The Department of Homeland Security has just announced proposed rule changes that could fundamentally alter how asylum claims are processed in the United States, and the impact of these changes reaches far beyond the immigration system itself. Right now, hundreds of thousands of people who have filed asylum claims are authorized to work legally in the United States while their cases are pending. And the proposed rules being put forward by DHS are specifically designed to sever the connection between a filed asylum claim and the automatic pathway to work authorization that has existed under the current system. The government's stated reason is straightforward. DHS has concluded that a significant number of asylum claims are being filed not out of a genuine fear of persecution, but specifically and strategically to gain access to the employment authorization document, the work permit. That becomes available to asylum applicants after a certain waiting period. If these proposed rules move forward, the implications for people currently in the asylum system, for people considering filing, for employers who rely on asylum-based work authorization, and for the broader immigration landscape could be enormous. Today, we are covering every aspect of what DHS is proposing, what it means for the people affected, and what the timeline looks like for when these changes could take effect. Hello, everyone, and welcome back to U.S. Benefits Update. I am your host, Claire Hollister, and thank you so much for joining us today. This channel covers immigration policy updates, government benefits, and the legal changes that directly affect the lives of millions of people across the United States, and today's story sits squarely at the center of all of those topics. The asylum system and the work authorization that flows from it affects hundreds of thousands of families, workers, and communities across the country, and understanding what DHS is proposing, why they are proposing it, and what it would actually mean in practice is essential for anyone who is connected to the asylum process or who wants to understand where immigration policy is heading. Please stay with us all the way through, because the sections on who is affected and what the real-world impact looks like are going to be particularly important for anyone currently navigating the asylum system. Here is the core of what the Department of Homeland Security is proposing and why it is generating significant attention across the immigration legal community. DHS has put forward proposed regulatory changes that would modify the rules governing the issuance of employment authorization documents, commonly known as EADs or work permits, to asylum seekers. Under the current system, individuals who file an asylum application with USCIS become eligible to apply for a work permit after their case has been pending for 180 days, which is approximately 6 months, provided their own delay did not cause that waiting period to extend. This 180-day waiting period was established to discourage the filing of frivolous asylum claims solely for the purpose of obtaining work authorization. But DHS now argues that the current system has not been effective enough at achieving that goal. The proposed rules would establish new and more stringent criteria for determining who among asylum applicants is eligible to receive work authorization, rather than treating eligibility as an automatic consequence of having filed an application and waiting out the required period. The specific mechanisms being proposed include enhanced screening of asylum applications for fraud indicators at the work authorization stage, new requirements for demonstrating the legitimacy of the underlying asylum claim before work authorization is granted, and potentially a separate adjudication process for work authorization that is more explicitly tied to the merits of the asylum claim rather than simply to the passage of time. DHS Secretary officials have been public about the rationale driving these proposals, stating clearly that the agency has seen evidence of a pattern in which asylum applications are filed by individuals who have little or no genuine basis for a fear of persecution, but who are motivated primarily by the desire to obtain the work permit that comes with a pending asylum case. The department points to the dramatic increase in asylum filings in recent years as partial evidence of this pattern, arguing that the volume of filings far exceeds what would be expected based on the actual level of persecution occurring in the source countries, and that the correlation between asylum filings and work authorization eligibility is a significant contributing factor to that volume. To understand why this proposal is so significant and why it is so contested, we need to understand the current asylum system and the specific connection between asylum claims and work authorization that DHS is targeting. The asylum system in the United States provides protection to individuals who have fled their home countries because they face persecution based on their race, religion, nationality, membership in a particular social group, or political opinion. Asylum is a protection that the United States is obligated to provide under both domestic law and international legal commitments, and the right to apply for asylum is available to anyone who is physically present in the United States regardless of how they entered the country. The connection between asylum claims and work authorization was established through regulations rather than statute, meaning it was created through the regulatory rulemaking process rather than through an act of Congress. Under the existing regulations, asylum applicants who have had their applications pending for at least 180 days without a decision are eligible to apply for an EAD that allows them to work legally in the United States while their case is being decided. The purpose of this provision was humanitarian in nature, recognizing that asylum seekers often cannot safely return home and may need to support themselves and their families during what can be a very long adjudication process. The waiting period was designed to ensure that people were not simply filing asylum applications as a fast track to work authorization, since a 6-month wait was assumed to be sufficient to deter purely strategic filings. What DHS is now arguing is that the 180-day waiting period deterrent has not worked as intended, and that the overall structure of the asylum-to-work authorization pipeline has become an attractive pathway for people who are not genuinely fleeing persecution, but who want authorized employment in the United States. The proposed changes reflect the administration's view that a more rigorous connection between the substantive merits of an asylum claim and the availability of work authorization is necessary to restore the integrity of the asylum system and to ensure that the humanitarian protection it offers is reserved for those who genuinely need it. Let us now be precise about who would be affected by these proposed rule changes, because the scope of the potential impact is broad, and it is important to distinguish between different categories of people in the asylum system who would experience the changes differently. The most directly affected group is current asylum applicants who are in the waiting period before becoming eligible to apply for work authorization. For individuals who have filed asylum applications and who are approaching or waiting for the 180-day mark, the proposed changes create significant uncertainty about whether the work authorization pathway they expected will be available to them on the same terms. If the rules are finalized and take effect before they reach work authorization eligibility, they could face new requirements or more rigorous screening before being able to obtain a work permit. People who already have work authorization based on a pending asylum application, meaning those who have already received their EAD, are in a different position. Their current work authorization is generally valid until its expiration date, but the renewal of that work authorization when it expires could potentially be subject to the new rules depending on how they are structured and what transitional provisions are included. The specific treatment of existing work permit holders under the new rules is one of the most important implementation details that will need to be addressed when the rules are finalized. Genuine asylum seekers, meaning people who have fled real persecution and who have legitimate and well-founded asylum claims, are also affected by these changes, and their situation is one that advocates have highlighted most urgently. If the new screening procedures for work authorization eligibility add time, complexity, or uncertainty to the process of obtaining a work permit, genuine asylum seekers who need to support themselves and their families during what is already a very difficult period will face additional hardship. The challenge of designing fraud detection measures that effectively screen out strategic filers without creating barriers for legitimate claimants is one that immigration policy experts have grappled with for many years. And the proposed rules have been criticized by refugee advocates precisely because of the risk that they will harm genuine protection seekers. Let us talk about the specific financial and employment implications of these proposed changes, because for the hundreds of thousands of people currently in the asylum system, work authorization is not an abstract benefit. It is the mechanism that allows them to pay rent, buy food, support their children, and contribute to their communities while their cases proceed through an immigration system that can take years to reach a final decision. An employment authorization document allows the holder to work for any employer in the United States in any lawful occupation, to obtain a Social Security number, and to access many other benefits and services that are tied to work authorization status. For asylum seekers who have been waiting for months for the opportunity to work legally, the EAD represents the transition from dependency on community support, charity organizations, and family networks to self-sufficiency and active participation in the economy. The ability to work legally is also connected to mental health and dignity in ways that are well documented in the research on refugee and asylum seeker welfare. And delays or new barriers to work authorization have measurable negative effects on the well-being of people who are already managing the trauma of having fled dangerous situations. If the proposed rules add new screening requirements or new substantive hurdles to work authorization eligibility, the practical effect for many asylum seekers will be a longer period of waiting and uncertainty before they can begin working legally. In an already strained system where asylum cases can take 2, 3, 4, or even more years to be decided, any additional delay in reaching work authorization has compounding effects on people's financial stability and their ability to establish themselves in their communities. Immigration attorneys who work with asylum seekers have consistently identified timely access to work authorization as one of the most critical factors in determining whether their clients can survive financially while their cases are pending. Understanding where these proposed rules are in the regulatory process and what the timeline looks like for when they might take effect is important for everyone who is affected or who is planning around the current rules. The regulatory rulemaking process in the United States involves a specific sequence of steps before a proposed rule can become final and enforceable. DHS has published its proposed rules through the standard notice and comment rulemaking process, which means the agency has published the text of the proposed rules in the Federal Register and is accepting public comments for a specified period. The public comment period is an important stage in the rulemaking process during which individuals, organizations, legal experts, advocacy groups, employers, and anyone else with a stake in the outcome can submit formal written comments expressing support for or opposition to the proposed rules and providing evidence and arguments that DHS is required to consider. Immigration advocacy organizations, legal services organizations, and civil liberties groups have been organizing comment submissions, and the volume of comments received during this period will be part of the administrative record that shapes the final rules and that forms the basis for any subsequent legal challenges. After the comment period closes, DHS must review all submitted comments and publish a final rule that responds to the substantive issues raised in those comments. This process typically takes several months to a year or more for complex rules like these, meaning that the final rules are unlikely to take effect immediately and that there will be a period between now and the effective date of any final rule during which the current rules remain in place. However, given the current administration's stated priority of implementing stricter immigration enforcement measures as quickly as possible, it is reasonable to expect that DHS will move through the rulemaking process with relative urgency. For people who are currently in the asylum process and approaching their 180-day work authorization eligibility date, the most important immediate action is to consult with a qualified immigration attorney about their specific situation. The current rules remain in effect during the rulemaking process, and people who become eligible for work authorization under the current rules before any final rule takes effect should generally proceed with filing their EAD applications under the current process. However, the uncertainty created by the proposed rules is a factor that needs to be incorporated into anyone's immigration planning, and professional legal guidance is more important than ever in this environment. The response to DHS's proposed asylum rule changes from the immigration legal community, refugee advocates, and policy analysts has been extensive and largely critical, though the debate includes a range of perspectives that reflect the genuine complexity of the underlying policy challenge. Let us walk through the key viewpoints that are shaping the conversation. Immigration attorneys and refugee law specialists have raised significant concerns about the due process implications of adding substantive merit screening to the work authorization process. Their argument is that the asylum adjudication process itself is the appropriate venue for evaluating the merits of an asylum claim, and that interposing a separate merits evaluation at the work authorization stage effectively creates a two-stage adjudication that disadvantages claimants and adds complexity and delay to an already overburdened system. These attorneys note that asylum claims are frequently complicated, that evidence takes time to gather, and that a claim that might appear weak at the early stages of a case often develops into a well-supported claim as the applicant has time to document their experience and present their case fully. Applying a preliminary merits filter at the work authorization stage risks denying work permits to people with legitimate claims who simply have not yet had the opportunity to fully develop and present their case. Policy analysts who study immigration enforcement and asylum systems have acknowledged the reality of strategic asylum filings while questioning whether the specific approach DHS is proposing is the most effective or the most equitable way to address the problem. These analysts point out that the underlying issue, which is a mismatch between the demand for legal work authorization pathways and the supply of such pathways in the existing immigration system, is not addressed by making the asylum-to-work authorization connection harder to use. If people who want to work legally in the United States do not have access to suitable legal pathways, they will use whatever legal pathways are available. And restricting those pathways without expanding alternative legal work options may simply drive behavior into less visible and less authorized channels. On the other side of the debate, immigration restrictionist organizations and some law enforcement advocacy groups have expressed support for the proposed rules, arguing that they represent a necessary and overdue effort to restore the integrity of an asylum system that has been systematically exploited. These voices argue that a system where filing an asylum application is an effective strategy for obtaining work authorization, regardless of the merits of the underlying claim, is not functioning as intended, and that the harm to genuine asylum seekers from a more rigorous system is outweighed by the benefit of restoring the system's credibility and effectiveness. Let us bring this down to the level of real people and real communities, because the policy debate, as important as it is, can sometimes obscure the very human stakes of what is being proposed. The people who are most directly affected by these rule changes are not abstractions. They're individuals and families who are navigating one of the most difficult experiences a person can face, and the specific implications of these changes for their lives deserve careful and concrete attention. Consider a woman from Venezuela who fled political persecution after her husband, a journalist, was imprisoned by the government. She arrived in the United States, filed an asylum application with the help of a legal services organization, and has been waiting for her case to be decided while living with relatives and participating in an English language program. She is approaching her 180-day eligibility date for work authorization and has been counting the days until she can legally work and begin supporting herself independently. Under the proposed rules, if her claim is subject to additional screening before work authorization is granted, her transition to self-sufficiency could be delayed for months while the additional review is conducted, extending her period of financial dependency and adding stress to an already extremely difficult situation. Or think about a small business owner in a major city who employs several workers who have work authorization based on pending asylum applications. These workers are legally authorized to work, have social security numbers, are paying taxes, and are valued members of his team. If the proposed rules create uncertainty about the renewal of their work authorization or result in delays in the renewal process, the business owner faces the very practical problem of potentially losing trained employees whose work authorization lapses during a protracted rescreening process. With no immediate ability to replace them and with the employees themselves facing a gap in their authorized employment status. For communities across the country that have significant populations of asylum seekers who have been working legally through the current system, the proposed changes create a climate of uncertainty that affects not just the individuals directly in the asylum process, but the broader community networks around them. Churches, community organizations, schools, And local businesses that have integrated asylum-seeking workers and families into their communities are watching these developments closely and expressing concern about the impact of increased barriers to work authorization on the stability and well-being of community members they have come to know and value. Let us close with a clear and comprehensive summary of everything we have covered today. The Department of Homeland Security has proposed regulatory changes to the rules governing employment authorization for asylum seekers, with the stated goal of cracking down on fraudulent asylum claims that are filed primarily to obtain work authorization rather than out of a genuine fear of persecution. The proposed changes would add new screening requirements or substantive merit evaluations to the work authorization eligibility process, going beyond the current system in which eligibility is tied primarily to the passage of 180 days from the filing of the asylum application. The proposals are currently in the public comment period of the regulatory process, meaning they are not yet final and are subject to revision based on the comments received before a final rule is published. If you are currently in the asylum process and approaching your work authorization eligibility date, the most important step you can take is to consult with a qualified immigration attorney as soon as possible. The current rules remain in effect during the rulemaking process, and understanding your rights and your timeline under the current system is essential for protecting your interests. If you have already received work authorization based on a pending asylum application, monitor your expiration date and consult with an attorney about your renewal options in light of the evolving regulatory landscape. Stay informed by following updates from USCIS, DHS, and trusted immigration legal services organizations, and use the public comment process to make your voice heard on these proposed changes if you are affected by them. Before we wrap up today, we want to hear from you. Are you currently in the asylum process and have questions about how these proposed rules might affect your work authorization? Are you an employer who has workers with asylum-based work authorization and is concerned about the implications of these changes? Do you have questions about the public comment process and how to submit a comment to DHS? Drop your questions and your experiences in the comments section below. Sharing information within our community is one of the most valuable things we do, and your situation might be exactly what another viewer needs to understand their own. If this video helped you understand DHS's asylum rule proposals more clearly, please give it a thumbs up and share it with anyone in your life who is navigating the asylum system or who wants to understand where immigration policy is heading. Subscribe to US Benefits Update and turn on your notifications so you are always first to know about immigration updates and policy changes that affect your life. I am Claire Hollister, and thank you so much for watching today. We will see you in the very next video.